Okay, time to make our way here. Pulling out of the driveway a little later than I had anticipated. I am headed to another pretrial hearing, or I don't know if they call this, on the paperwork they call this a disposition hearing, but when you study disposition hearings in criminal cases, it involves investigating the evidence closer by the judge and having both sides of the case be adversary and really challenge each other's evidence to see what will be admissible or what could actually be thrown out, what could throw out the case entirely. But on the paperwork, that's what it says. It seems more like it's a pretrial arraignment to me, or something of that nature, or maybe a pretrial conference. When you do investigations into what type of court you're dealing with, I apologize about the strange angle. I forgot the phone holder, so I've got this kind of down right below the stick shift there. But when you start trying to research what kind of court you're actually facing, whether it's a county court or a district court or whatever the case may be, all those type of courts, under whatever heading they are, could be a lot of different types of courts, and you really have to investigate what kind of court you're dealing with. Although you're going to make the court prove to you who they are, you still need to know before they even do that. And so in investigating this county courthouse in my, it's not my hometown, but where I live, so it's my hometown now, it was really difficult to kind of understand what they call this. It'll be the second try for this. If you didn't see the previous video, that was my first time to quickly have a meeting with the district attorney, who was probably 28 years old, which, I'm not ageist or anything, but that certainly gave me a lot of confidence. And we didn't really do any kind of private consultation. We had a quick meeting just on the side of the courtroom there, and she gave me her deal. And it involved a year of probation and fines, and really the year of probation was the real downer. I might have actually just taken the fines, not because I'm guilty, but just to get this done with. I have so much business to deal with that this is just, it's fascinating, and it's one of those things that God has brought me to, and I'm excited about it because it's a topic that I had been preaching on anyways. If you've seen the previous video before that, it's becoming more and more interesting to defend myself in court as I get in trouble, mainly by just making people mad. Anyways, long story short, I've become some habit of it. I'm obviously chasing not only wisdom, but I'm proving to myself and to anyone else who might be watching that the Bar Association is a monopoly on the courtroom and on our freedoms, or on justice, or any way you want to see it. And there's a lot of smoke and mirrors to make you believe that you need the Bar Association, despite them being on both sides of the aisle. And so me and some other people, some very brave people who faced some tougher than me, some less tougher than me charges, are out there trying to prove that we can do this by ourselves, DIY, sovereignty style, that there's really whatever magic that is being trying to be conducted in these courtrooms. There's a lot of ways for you to attack them and to reserve your rights, and honestly, to a certain degree, and this is not a universal clause in my book yet, but at least for my case, considering the cost and what these defense attorneys are willing to do for you, your case cannot be better served than by you yourself if you are, a competent reader, have time on your hands and some interest to understand some of the stuff. It's really not as difficult as you think. It certainly doesn't take 8 years of schooling. You only have to deal with one case. They have to deal with, 35 cases of all kinds of natures throughout the year. So in that situation, you only have to be proficient in your case. That's a huge advantage. It's kind of like when you go interview for a job. The interviewer has to interview people all week long, all day long, so they have to have, a sharp suit every day, but you as an interviewee, you just have to be good at that one interview. You just need one suit. And that's kind of where I'm at. I just have to be proficient in my case. She's got to worry about all her other cases, as I assume, because she's really lacked reading this report. So one of the things that I requested was discovery, which they kind of ignored, and whether or not the judge will look at my writ of discovery and see that as a possible reason to throw the case out will be interesting in itself. However, I should go this way. However, aside from that, what I did get from discovery, which is hilarious, because I ordered them to send me all this information to my place and told them where to send it, and they made them sign the document agreeing that they would do that, and they never did. And I did some investigating as to how you are supposed to find discovery, and some deep pages into the website of the sort of the county government homepage. If you look deep enough, you can find out that you're supposed to go pick up your discovery, make an appointment with the DA, and go pick it up yourself. That'll be available right away, actually, and they put it on a CD for you, a CD-ROM. I didn't find that out until about 2 weeks ago, and I went and picked it up. And I'm not sure if they're playing by the rules there, but it's neither here nor there. One of the most invigorating things about the situation is I'm not fighting this just to fight this. I'm fighting this on two principles. One, I'm not guilty. And two, this is a huge case. Well, it's not a huge case, but it's a stepping stone in a culture development that is taking place, and I'm in one of the lead states for it. I'm in Colorado, and the cannabis laws, especially the medical cannabis laws, which I fall under, are being jeopardized. And there's being bad science put forth to prosecute people. So, my point is not only am I innocent in this case, but there's also a larger situation of a cultural, I don't want to say revolution, because it's more of a cultural, a reculturalization of the demonization that cannabis has gone under. And we'll go extensively into that as we get closer to the evidence, and that'll be a video on its own on the science behind impairment in cannabis. But there's a third reason now, and of course this boils my blood, but it's just, I guess, another calling, in that when you read, the state's only evidence in this, because I refused a blood test, which normally isn't a good situation in cannabis cases. Reason being is there's been so many cannabis cases that have won under trial by taking the blood test and proving that there's no way to assert what that blood test shows in terms of impairment, because there's no science that shows what level threshold involves impairment. Versus alcohol, it's very, very obvious. In cannabis, it's very hard to even understand if there is any impairment, and certainly that threshold hasn't been proven whatsoever. And so taking the blood test shows your feeling of innocence, and then you can kind of defend yourself from that, like prove that level is impairment, and that level can be separated from the normal 28-day, 35-day cycle that cannabis can stay in your system, not impairing you in any way, if there is impairment, as they say. But in this case, I refused, because I was a little bit ignorant in the situation, because the old rule in alcohol, which I don't ever drink, but the old rule in alcohol DUIs is you refuse the blood test, because they know exactly what levels of impairment are. And if they get you above, I think it's, 0.1, the penalties become very, very stiff. Extremely. I mean, it goes from basically what I'm facing is a second misdemeanor out of 3. It would go from that, even on a first offense, to a class 2 felony at least, depending on how high the alcohol level was. Again, in a cannabis test, if you took that blood test, no science to prove that. So in front of a judge or jury, most likely a jury, which you have the right to in these cases, anytime you are challenged criminally, you have the right to a jury with your peers. Anyways, in that situation, you're looking at no science, no way to prove what level causes impairment. However, I refused, like I said, because out of ignorance, and mostly I was just mad because I took a roadside test in complete confidence that I was not impaired. My car was searched to find nothing. I passed the roadside test. He found some small little rinky-dink things to say that I failed it. And so I was just really ticked off with him and his integrity. I asked him for his card 3 times. Mostly when he took possession of my car, he wouldn't even offer me a business card. I gave him mine right away. I was completely cordial. He even put that in the report, that I was completely cordial and whatever the word is, I was nice. And I didn't withhold anything or try to be any way. Although he did describe me as cocky out of the 5 behaviors that show that you're impaired, which out of the other 4, I certainly wasn't vomiting, stumbling. I think one of them was like passing out or something of that nature. So, moving on. The point being is all they have is this judge's test. Okay, well, no, that wasn't. The point was that the whole reason I didn't want to take the test mostly was just because I was so upset with the integrity of this car. I knew I had something strange going on with the police officer I was dealing with. This wasn't our normal our normal Denver, Colorado police officer. I don't know if he was under what kind of leverage he was under in terms of work pressure. The whole what's the word for that quota situation, because it was towards the end of the month. I don't know, but for whatever reason, he did everything he could to make this into a case. And it took everything he could to do it. Their only evidence at this point, this is the good side of not taking the blood test, is his and his assistant, who he called in to drive me away because he was on a motorbike. Those 2 guys, their testimony. So far, they have produced no video, which, the video would prove that he is an absolute liar. I don't know if I'm going to subpoena that or not, or if there even is that or not. But a video would be clear. Basically, every single line of his statement, I put the statement in the back of the car or of the SUV, but if you saw it, it looks like one of my English papers in college. It was just completely torn up. The man fabricated everything. As we get more into the evidence, I'll describe how salacious he was in the actual pullover and how he solicited me and tricked me into taking the test in the first place by telling me that he was convinced I wasn't impaired. And that's a long story in itself. He's a very tricky guy, and he went way beyond than he needed to go, really. The lies he made up and the contradictions throughout the testimony, it's almost laughable, except that it's not funny. We're dealing with somebody nefarious at this point, and if I don't put an end to it, it could be worse for someone else. Not only because someone else normally wouldn't have the time or the will, I guess, or the stupidity to try to do this themselves and stand up for themselves, because most of us have families and work and really huge concerns that we can't take time out of our day and stress out the people that we love to becoming an expert in this situation. And so we will take it up the ass, and sometimes that could mean ruining families, even breaking up families in this situation, and a lifetime of being on a hamster wheel of fines and just being at the whim of them. Once you're in for a year, this is a long story in itself. I'm trying to keep this short as I can. Point being, we now are dealing with something of a nefarious, dirty officer in this situation, which I hate to say. It pains me. When I read it, it was like, hearing from my dad tell lies or something of that situation. I knew he was under some duress to push the case along that day for some odd reason. But, to take it to the point he did in trying to describe this case and make a case out of it, he really spun a web that there's no way he could get himself out of. It's been since college since I got to cross-examine anyone. And normally in the type of cross-examinations that I would do in college, we got 5 minutes. This is not going to be 5 minutes. This is going to be painstaking. This is going to be long. I'm going to get my money's worth. And the first step is today. I go in there and I plead not guilty. I'm trying to see when he wants me to file motions at this point, because I have a list of motions that is as long as my leg. I'm hoping that he just wants me to file them in writing. The judge is awesome. I have the best judge I could possibly ask for. I kissed his ass a little too much already, but that's okay. Yeah, so I have a chance to, I'm going to plead not guilty. I'm not going to talk to the DA. You know, I had thoughts of going and talking to the DA before the case and telling her, hey, I'm not pleading guilty and you should look at this thing, and you're going to find yourself in a lot of liability if you don't fix this, if you don't get out of this situation. But you don't want to show your cards ever. Okay? They're on the attack. It's a great life lesson too. If someone's attacking you irrationally and they're asking you for answers, or it's waiting, expecting you to call them back because they attacked you in a text and a call and rumors, and they're just waiting there because they know you're waiting for you to you know, to react and to give them that hate that they were begging for by doing this type of attack. Never give the satisfaction of giving them that reaction right away. Silence is not only your best weapon, but it is your most torturesome weapon as well. You just wait, and you just let wisdom spill over you until you have to absolutely put it on the line. And by that time, you will be so prepared. And the other side will be so resentful, so scared, so presumptive of what you have to say that you'll barely have to say anything. So you never show your cards in these situations. They're on the attack. You act on it. You don't have to. Alright, well, we'll be recording the proceeding if we can. I still don't know if that's against the law or not. I'm going to try to find some signage and take some pictures on the other side. I'll try to load this beforehand too. I'm not getting there as early as I had hoped, but I'll try to load this on their Wi-Fi. And after that, if everything, we'll hit some golf balls at Old Riverdale. Alright, this time wish me luck.